Hey everybody, I'm attorney Jason McGrath with the law firm McGrath and Spielberger. I practice in North Carolina primarily, but also in Florida and Tennessee, and my law firm practices in these additional states you can see here over my shoulder. I want to talk to you a bit about the difference between mediation and arbitration. These are both forms of what we call alternative dispute resolution. Basically, it's a fancy term for particular specific ways you can resolve a case without having a trial. And what a lot of people, it's interesting, having done trial work for 19 years now, I guess I'm getting old. But anyway, it's interesting to me that so many people really don't have even a general understanding of the legal process, the litigation process, when you can resolve a case and settle a case, when you can't. By the way, you can almost always settle a case as far as what stage of the dispute you're in. So some people think that, well, if you go to mediation and the case doesn't work out, then you can't resolve the case, so you can't settle it. And that's not true. You can almost always settle a case as far as the timing of the settlement. Mediation and arbitration are typically quite different, even though they're thrown in together sometimes. Your typical mediation is not a binding procedure. There's no judge there. There's no equivalent of a judge there. There's no arbitrator there. Nobody's sitting in judgment. There typically is a mediator, which is one reason it's called mediation, and the parties are there. And the mediator typically serves as a neutral, person who is interacting with both sides or all sides. If there's more than two sides in the lawsuit, and trying to facilitate a settlement. And a mediator might have some discussions, or would have discussions with both sides, who are typically going to end up in different rooms in the same building or same office. And the mediator will hear some information from, say, the plaintiff that is partly confidential, partly not confidential. The mediator will hear some information from the defendant, which might be partly confidential, partly not confidential. Good mediators may share their own opinions, although in an objective manner, and just facilitate negotiations trying to get the case resolved. And mediation is a much less formal proceeding than an arbitration, and they're both less formal than an actual trial. They're also both typically much less expensive compared to actually having a formal trial within our legal system. Arbitration really is a private trial, so you could have a regular lawsuit filed, but because of some agreement that existed, like a contract, where it says you have to arbitrate any disputes, you might end up in arbitration. Occasionally you'll have a judge basically order that you arbitrate. Although the judge orders you to arbitrate, usually the judge is not going to try to order a binding arbitration. And binding arbitrations are usually the type you want to engage in, not always. And then sometimes you'll be in a lawsuit, or even before a lawsuit, and the parties will the parties' lawyers will say, you know what, why don't we just arbitrate this? Because we don't really want to go through 2 years in the legal system and quadruple the legal costs. Now I did a comparatively small lawsuit that started about 2 years ago now, and we were in the regular legal system for a little while. But there was a pre-existing agreement to arbitrate, which we pointed out to the judge. Our client said, yeah, let's go ahead and arbitrate it. And we did arbitrate it and resolved that about a year ago now, actually. And the total costs involved in that case were about $35,000, as I recall. Not the award or the settlement, but about attorney's fees and arbitrator's fees and all of that. And like I said, that was a small case. So even a small case costs tens of thousands of dollars, and that was just the amount, for one side. But arbitration, basically, you show up kind of like you're going to trial, only you're usually have either one arbitrator there or maybe three. That's the most common, to have one or three. You want an odd number for kind of obvious reasons, a tiebreaker type vote, or just have a single person deciding. Arbitrators can issue detailed written findings and decisions, or just very generic findings and decisions. That's something they usually discuss with the parties and the arbitrator. So the arbitrator might actually have a meeting before the arbitration, and certainly would have conversations with the parties before the arbitration in the weeks and months leading up to the arbitration, and to establish the ground rules and make sure everybody's on the same page, that kind of thing. And usually, but not always, usually the parties end up splitting the costs of the mediation or the arbitration, including the mediator fees or the arbitration fees. Occasionally you'll see it for an arbitration where the quote-unquote losing party has to pay those fees. But sometimes who the winner is and the loser isn't entirely clear. For example, it might be that a defendant more or less privately admits that they owe the other side $100,000. So if you go to arbitration and the arbitrator says, hey, you owe them $100,000, well, if the defendant kind of knew that all along and the plaintiff wanted $300,000, well then to the defendant that's kind of a win almost, even though there's a decision against the defendant for $100,000. But anyway, so arbitration, the lawyers go, the parties go, you present your evidence, you question witnesses, people are under oath, you have a court reporter there if you want one. I certainly advise that, even though it costs money, And arbitrators' decisions are typically appealable to some extent in the formal court system. But the purpose of arbitration usually is to reach a final and binding decision. And so typically your options to appeal after an arbitration are actually fewer than your options to appeal after a jury verdict in the formal court system, for example. And an arbitrator's decision actually does get filed with the court and can be enforced through the court system, that kind of thing. So typically an arbitrator in a lot of ways actually ends up having more power than a judge does, at least as far as the deciding on a case, the legal decision on a case. So I hope that has helped to clarify the distinction between mediation and arbitration. Again, both can be ordered by a court. Mediation generally is not binding on anybody. It's a negotiation. Can be very, very helpful, but also sometimes can be, kind of expensive. You can be there all day or on more than one day. Arbitrations can last a couple of hours or a couple of days or a couple of weeks, depending on how, large the case is, how many issues there are. But arbitrations are certainly almost always notably less expensive than trials and notably shorter than trials. And you are putting your decision in the hands of that one arbitrator or three arbitrators or whoever it might be. So that's that. And we handle mediations, arbitrations, and lawsuits of various types. And if you need help with something like that, go ahead and let us know. Of course, it has to be in one of our states where we practice. It's a legal thing that we're restricted for good reasons. But in any case, I hope this was helpful, and good luck to you. Thanks.